Hey, estate planning attorney Paul Rabalais here, and in this video we're going to talk about how in order to get certain estate protections, you have to be willing to relinquish some element of control. All right, so some people think estate planning is merely drawing up a will and saying where your stuff goes when you die, but many people who have the estate planning talk with me, they want advice and action regarding protecting their estate. Whether those protections are from taxes or from medical or long-term care, or to be more specific, nursing home expenses, or some people want to have assurance that their estate is kind of quote-unquote protected from lawsuits. All right, now some people initially, at least before they watch videos like this, they come in assuming that they can have their cake and eat it too. They want all these protections in place, but they also want to remain 100% in control of everything they have. But it doesn't necessarily work that way. The following is really an example of the different kinds of protections that people want and why it's necessary that you'll have to give up at least some element of control in order to gain those protections that you're looking for. Okay, so the first of three that I'm going to talk about is some people want to protect their estate from estate tax. Not a whole lot of people, because these days we have this $11.58 million exemption, and very few people have more than $11.58 million estate, so they're not going to be subject to the 40% estate tax. But when it does apply, it applies in a big way. The government takes 40% of everything that someone has in excess of $11.58 million when they die. Oh, by the way, that number is probably going to come back to about $6 million in 2026. That's talking pretty fast. I hope you didn't have it on 2 times the play speed. But some people want who potentially face who their estates potentially face the estate tax in the future. They want to remove assets from being subject to that 40% estate tax. And I realize some people, many people transfer their assets to a revocable living trust, and they do it so that when they die, their survivors don't have to go through the court and attorney involved probate proceeding. But assets, and when you put assets in one of these revocable living trusts, you can do whatever you want to with them. You are still 100% in control of them. You can buy, sell, spend, do whatever you want to do, give the stuff away if you want to. But assets in your revocable living trust are not out of your estate for federal estate tax purposes. So to get assets out of the estate for federal estate tax purposes, you essentially have to either just make outright gifts to others, completely relinquishing control, no ability to get those assets back. You have to be willing to do that. Or some people put assets in a trust, but in order to get it out of their estate, but in order to get it out of their estate, you cannot be any kind of beneficiary of that trust. And many people feel like you should not even be a trustee of that trust. So in order, to get the estate tax protection, you have to be willing to relinquish complete control, at least over those assets that you want to get out of the estate. Now, some seniors who have a lot of money, who have a large estate, they're comfortable allowing some of the assets that they own to get out of their estate because they know they have more than they need, more than they could ever spend during their lifetime. Now, others, however, some don't, to avoid estate tax, they don't like giving up that control that they have to give up by getting assets out of their estate, either because they are, kind of a strong word, control freaks, or they don't like the idea of allowing others to have control. So those are all issues that we have to deal with in the protection from estate tax conversation. The second kind of protection that's really common these days in America is the protection from from nursing home expenses, or you could even say medical expenses. Some people are worried about that as well. So the concept is, particularly as it relates to nursing homes these days, depending upon where you live, what city, what state, what community, those nursing home expenses can range anywhere from maybe $6,000 a month to maybe $12,000 or $13,000 a month. And our system is set up where if you have assets in your name when you go into a nursing home, and if those assets exceed $2,000 in value, whether you have $10,000 in assets or whether you have $2 million in assets, you've got to be a private pay patient in the nursing home or private pay resident, and you have to deplete all of what you have until you spend it all down to less than $2,000. And then once you've spent it all down, then you can apply for and qualify for your state's long-term care Medicaid program. So the rules are, and obviously many people want to try to protect their estate from having to go through what they call that spin down. So the rules are, in general, if you do have, control, access, the ability to spend an asset, then that asset is what Medicaid calls a countable resource, and you must deplete it or sell it and deplete the proceeds from the sale before you're eligible for any kind of long-term care Medicaid assistance. Now, many seniors in the middle class, they've scrimped and they've saved for 50 years to accumulate a few $100,000. And while they realize they would be forced to spend those assets at $6,000 to $12,000 per month if they enter a nursing home in the future, it just kind of goes against their grain to give up control over what they've worked so hard over decades to accumulate. But in order to, quote unquote, protect those assets from the nursing home, those seniors are going to have to relinquish control. And not only are they going to have to relinquish control, they're going to have to relinquish control at least 5 years before they enter the nursing home. So this is a big one. Whereas in the estate tax, people tend to just get certain assets out of the estate because they can retain millions of dollars in their estate and still their estate would wind up paying zero estate tax. For nursing homes, it's different. In order to attempt to make yourself eligible for long-term care Medicaid in the future, you've got to be really willing to give up control over everything you have, and you have to give up that control at least 5 years before you go into a nursing home, which of course nobody knows when that time period starts. Some people, not many, because of the fear of giving up control, some people just put all of their assets into their children's names. Boy, that is giving up control, and people don't like to do that because bad things can happen when you transfer what you've worked 50 years for. You just put it in your children's names. They could get sued, they could spend it, they have spouses, and sometimes there's issues there. They could pass away, and then the assets go on to their heirs, and they're just poof gone. So there are a lot of concerns about people giving up control by transferring ownership of their assets into their children's names. So to try to minimize that whammy, some people will put assets in a trust to try to better protect and retain some element of control. So when that's the case, the trust usually lasts for the lifetime of the parents. However, the parents, the people who transfer assets to this particular trust, if they're trying to get the assets out of their names and make those assets no longer a countable resource of theirs, then under no circumstances can they be what's referred to as a principal beneficiary of that trust that they've transferred assets to. Under no circumstances can those parents have the right to go in and remove the assets from the trust and put them back in the parents' names. If they have that right, Medicaid will say, well, you've got to exercise that right and you got to spend those assets if you go into a nursing home. So again, parents who want to have that protection from losing their assets because of nursing home expenses, they have to be willing to, again, relinquish control. And then the third scenario that people want protections from is a protection from lawsuits. We're in a litigious society. Paul, what if I get in a bad car wreck and I'm determined at fault? Somebody gets a $6 million judgment against me. I only have insurance up to $1 million. So now all of my personal assets are going to be at risk. The lawyers are going to take them. What do I do? Now, in the protection from lawsuits discussion, maybe there is a little bit of you can have your cake and eat it too. There are some types of assets that you can own that they are exempt from your creditor's claims. Things like, and it can be specific state by state, or it is specific state by state, but generally things like your 401k and your IRA, even if someone gets a judgment from you, nobody can take that away from you. So that's a little bit of certain things that you can own and control, and they're protected from lawsuits, while not protected from estate taxes, not protected from nursing home expenses. So it depends on what protections you're looking for. However, other assets that are in your name, or perhaps they're in your revocable living trust, they are going to be exposed to your future creditors. And people who are worried about, I want to protect my assets from lawsuits, they don't like the idea of just putting assets into their children's names, because now those assets are exposed to their children's creditors. So as a kind of scratch the surface conversation of how do I protect my assets from lawsuits, you see some people transferring, again, we talk about trust, transferring assets to a very particular type of trust. And maybe the children are the principal beneficiaries of that trust. And it's likely to be what's commonly referred to as a spendthrift trust. So now those assets are protected from the creditors of the parent because the parent doesn't own them anymore. And now those assets are protected from the creditors of the children because the children are merely beneficiaries of a spendthrift trust. And by its nature, spendthrift trust means the beneficiary's creditors can't seize the beneficiary's interest in the trust. So some people feel good about the kind of asset protection or lawsuit protection that those types of trusts provide. Again, I'm in Louisiana. You're wherever you are. You might not even be in the United States. But this is an area where you have to really get informed about your particular state's rules so you comply with whatever rules you need to comply with. But the bottom line or the conclusion on this, how do I get these protections, is there's just really, in order to get certain protections, you just have to be willing to relinquish some element of control. How much control do you have to give up depends on what kinds of protections you're looking for. And even reasonable minds or different lawyers can have different opinions on exactly what controls you have to give up in order to get the protections that you're looking for. So this is really just a scratch the surface to video to get you to understand that in order to get certain protections, you have to start to be familiar with the concept that you may have to relinquish some control. The other thing that's really important is that it is really important that you turn the gray like button to blue by hitting the thumbs up like button. That'll tell YouTube, hey, show this video to more people. And then also, if you haven't subscribed already, hit the subscribe button and the notification bell. That way you don't miss anything, because again, staying informed is really the key to understanding what you need to do to protect what you have for yourself and for your family. Okay, we'll see you next time. Take care.